Hi guys, it's finally Kathy. So Fozzie called to wake me up and he said, I don't think your internet's on because you're not online anywhere. And I'm like, yeah, I closed my Discord down because my cats start typing to people. He was right. My internet was completely out. I had to start it up. How did he know that? I should just check him first whenever my internet goes down. Is my internet down? All right. And then I got a call from CJ, and her accent is so delicious. Oh my God. We were going to just skip the stream and just chat instead, which would have been so cool. I do have a great accent today, though. Very, very great. The best part about this accent is he is audio only. So when you hear this accent, you can actually put whatever face to it you want. And I did. Let's see what we're going to start with. I should share my screen.
Miss Girl, did you understand?
I'm already scared. Okay, this judge scares the bejeebies out of me. But I'm going to start this judge with a nice heartwarming clip before he gets warmed up.
All of the rights and plea options I just explained?
Yes.
Do you have any questions regarding any of those?
No.
Okay. Did you receive a copy of the traffic citation issued on February 15th? You'll have to speak.
Oh, I'm sorry, yes.
Yes, okay, thank you. You are charged with one count of driving in marked lanes. That is a minor misdemeanor. It's punishable by a maximum $150 fine plus court costs. Do you understand the maximum potential penalties?
Yes.
And how do you wish to plead to this charge?
No contest.
Okay. Do you understand by pleading no contest to this charge that you're waiving all of those trial rights I explained to everyone earlier?
Yes.
You'd also be waiving your right to an attorney. Is that what you wish to do?
Yes.
Okay. No contest pleas are unique in Ohio. Before I can accept a no contest plea, the law requires me to obtain an explanation of circumstances. So can you tell me what took place on February 15th that led to the citation?
I was driving home from work. I was about 3 houses down from my house, and all of a sudden I felt my wheel go to the right. Next thing I know, I tried to get it to go back to the left, and it didn't work. And with it being an icky day out, next thing I know, I went in the ditch, hit the mailbox, and then I rolled about 3 or 4 times.
Oh my. Okay, so yes, there was an accident. Let's see.
Yeah.
Were you hurt?
Yeah.
Okay. Did, I do accept the explanation of circumstances. I do find the defendant's no contest plea to this charge to be knowing, voluntary, and intelligent. The court will accept the no contest plea, and I will therefore find her guilty of this offense. Was there any other, anyone else hurt in this accident? Just
No,
you?
it's just me.
Okay.
I was coming home from work.
Okay. Is there anything else you'd like to say at this time before I impose sentence?
Just that this is my very first time I've ever gotten anything. I've had a clean driving record up until now. I mean, this was just a fluke. I really, never had any issues, never had any tickets. I just, like I said, I tried pulling out and it just didn't work, so.
How long have you been driving now?
Do I really have to say?
Well,
Okay, so maybe about, 50 some years.
well, the reason I ask, Miss Girl, is because there's absolutely nothing on your driving history.
Right. What do you mean?
I don't see this.
No.
She's the safest
Yeah.
driver in Oxnard.
That's all right.
Yeah, I drive, I wear my seatbelt, I will not get in a car without wearing a seatbelt or anything, and it's like, when this happened, I was just blown away, because I never had anything like this happen.
Well, I'm amazed, because it's rare that I see this kind of driving history with someone in my court. So I commend you for your incredible driving record. And I can understand that, why you're a little nervous today. So, well, here's what I'm going to do. No fine, but you are going to pay court costs. Court costs will be $152. I'm giving you no fine because of just how amazing your driving record is.
Thank you.
You're welcome. Are you able to pay court costs today?
Yeah.
Yeah.
Okay, wonderful. And I do see that you provided the trooper your insurance, so we do
Yes.
have that. Okay. Well, keep up the great driving record. Hopefully we won't see it again. Yes.
Yeah, me neither, because I never plan on this happening again. This is just blown away, so.
Okay. Well, what you'll do is
It does tick me off that she's in court because of an accident. Like, she got into a car accident. She didn't hit anybody. The car went off the road, and that's illegal. You can't let your car go off the road. It was an accident.
leave the courtroom, you make a right to the clerk's window, and they'll take care of you, okay?
All right, thank you.
Okay, you have a great day. Thank
Thank
you.
Okay, enough. Enough with the heartwarming, guys. It's over now. Buckle up.
Court is now calling the City of Pontiac versus Nicholas Vincent Dalton, case number 25-280-140. Good morning. Mr. Dalton, did you understand all of the rights and plea options I just explained to everyone? Do you have any questions regarding those?
No.
Did you receive a copy of the traffic citation issued on February 26th?
Yes, I did.
Okay, you are charged with one count of expired plates. That is a minor misdemeanor. It's punishable by a maximum $150 fine and court costs. Do you understand that?
Yes, sir.
And how do you wish to plead to this charge?
Guilty.
You understand by pleading guilty that you're waiving all of those trial rights I explained earlier?
Right.
You'd also be waiving your right to an attorney. Is that what you wish to do? Yes, you'll have to speak.
Yes.
Yes, okay. Okay, I do find the defendant's plea of guilty to this minor misdemeanor offense to be knowing, voluntary, and intelligent. The court will accept the guilty plea, and I will therefore find him guilty of expired plates. Okay, Mr. Dalton, I'm going to proceed to sentencing. Is there anything you wish to say before I impose sentence?
No, sir.
Okay, the officer did write on the ticket that your plates expired back on July 31st of 2024.
I don't have an accent.
So you were driving several months without having renewed your plates?
That wasn't my vehicle.
Oh, okay.
Yeah. That was my friend's vehicle.
Okay. But you do assume the risk when you get in someone else's vehicle. Do you know if the plates have been renewed?
As far as I know, from there, she called a tow truck, and the next day took it to a garage, and while they were at the garage, she got the registration updated.
Do you drive this vehicle often?
No, I have my own vehicle. I was just trying to help her out.
Okay.
Her, what do you call it, alternator was bad. So we tried to take it for a little drive and see if it would charge it up, and it didn't work.
Do you still live in Edinburgh, Pennsylvania? Oh, where do you live?
I just moved in with my friend here in Springfield. I can't tell you the address right now. He's going to Happy Valley Road.
But you don't, you have a Pennsylvania driver's license.
Right.
The officer wrote it down, the ticket 2947 Happy Valley in East Springfield?
Yeah, that's
Okay. Okay, $50 fine, court costs, total fines and costs will be $202. Are you able to pay that today?
I'm not paying. She will, but I'll have to wait and see when she can do that. Not today, it'll be tomorrow, by the end of the week, nonetheless.
So you can pay it by the end of the week? Is that what you're saying?
I would imagine so, yeah. I have to clear with her, but.
Well, I'm gonna put a deadline on here by which you have to pay fines and costs.
Yeah, that's fine.
Okay, I'll give you until the end of the week, March 14th, to pay. Okay, Mr. Dalton, you
So apparently his friend's car wasn't working. He was trying to fix it. And he took it on the road to drive it to try to charge it. The alternator was bad. And he got nailed for that.
have any questions?
Yes, sir.
Okay, you can go to the clerk's window, they'll take care of you. Go right. Thank you.
Everybody's a far cry. Everybody. All right. Here we go.
Court is now calling State of Ohio versus Charles Lee Mendenhall, case number 25, TRD 153. Good morning. Mr. Mendenhall, did you understand all of the rights and plea options I explained to you earlier?
Yes.
Do you have any questions regarding those?
No.
Okay, did you receive a copy of the traffic citation issued on March 1st, 2025? Yeah. So you did receive it?
Yes.
Okay. Okay, you have two charges filed against you. The first charge is driving under suspension, violation of section 4510.11 of the Ohio Revised Code.
I'm not under suspension.
Mr. Mendenhall, I'm going to explain to you what your charges are. You are Charles DeJour Lee Mendenhall, correct?
Yes.
Okay, so you have two charges filed against you. So I'm going to explain to you what the charges are that were indicated on the ticket, and then I will, so why don't you listen to me? The first charge is driving under suspension, a violation of section 4510.11 of the Ohio Revised Code. It is a first-degree misdemeanor. If convicted of this offense, you face a maximum 180 days in jail. You face a maximum $1,000 fine. I could, it's optional, but I could impose an additional 1 year suspension on top of whatever other suspension you may have. And this would be technically a 2-point violation through Ohio Bureau of Motor Vehicles. So do you understand the maximum potential penalties you face if convicted of this offense?
Yeah.
The second charge is no driver's license, a violation of section 4510.12 of the Ohio Revised Code. I do have to ask, have you ever been licensed before?
Yeah.
Okay, so, because this is still your, this would be your first in 3 years, so this is a minor misdemeanor. If convicted of this charge, you face a maximum $150 fine plus court costs. You understand the maximum potential penalties you face on that charge?
Yeah.
So we're going to start with the first charge of driving under suspension, a first-degree misdemeanor. How do you plead to that charge?
No contact.
The second charge of no driver's license, a minor misdemeanor. How do you plead?
No contact.
Do you understand by pleading no contest to these charges that you waive your right to a trial, which includes your right to cross-examine witnesses and to confront evidence presented against you? You'd be waiving your right to testify or not to testify without any negative connotation.
Matter of fact, we'll check that with not guilty.
Okay. To both charges?
Yeah. But he told me.
I don't want to hear what he told you. Okay? Let me finish, please. I will accept your not guilty, please. Now I'm going to address the issue of an attorney. Do you wish me to consider appointing an attorney to represent you in this case?
No.
So are you going to represent yourself?
Yeah.
I always advise folks who are facing a possible jail sentence, who want to represent themselves, that, you know, it's not always a wise thing to do. You do have a right to counsel, your right to have an attorney represent you, and all I'm asking you is if you want me to consider appointing one to represent you.
Is the jail sentence for the driving without our license suspended?
You have 2 charges filed against you, Mr. Mendenhall. The first charge, as I said 3 times, is driving under suspension, which carries with it a maximum 180-day jail sentence. The second charge is no driver's license, which is a minor misdemeanor.
And all I gotta do is show proof that my license is not suspended.
Mr. Mendenhall, I'm not telling you what's going to happen after today. I'm just trying to deal with the here and now, okay? I'm just trying to deal with the present. And the present is, I just explained to you the charges and the potential consequences you face. And now you've indicated to me that you wish to represent yourself, and I'm advising you that that's not always a wise thing to do. So if you wish to represent yourself, that's fine, but I'm advising you that you do have a right to court-appointed counsel if you qualify. I don't know if you'll qualify, but if you want me to consider court-appointed counsel, I'm going to have to ask you some questions regarding your finances.
No, I don't want to.
So you're going to represent yourself.
Yeah. Or I'll get my own attorney.
Well, that's not how it works in this courtroom. Understood? Now, you be quiet and just listen, Mr. Mendenhall. Be quiet. I'm about to explain to you how it works here. You either tell me you're going to retain an attorney and show up with one, or you're going to tell me you represent yourself.
I'll retain my own attorney.
Okay, who is it?
I didn't get, I have to get one.
Okay, so you're going to retain your own attorney. If you show up at the next hearing without an attorney, you will experience my wrath. Because as anybody knows who've practiced before me or been before me in the last 5 years as a judge, when you tell me you're going to retain an attorney, you show up without one, you're going to experience my wrath. So I'm going to ask you again, Mr. Mendenhall, are you going to retain an attorney?
Yeah.
Or are you going to represent yourself?
I'll retain my attorney.
Okay. Now I'm going to address the issue of bond. The citation has you listed at 828 West Prospect, Apartment 5 in Ashtabula.
No.
Where do you live? You don't know where you live?
I don't know that hurt my heart. I just moved. 2826.
Oh, I'm a professional. That's called editing.
Ashtabula address?
Yeah. Or, no, it said Tommy.
Is that in North Kingsville or?
Yeah.
You said you've just lived there for a few months. How long have you lived in Ashtabula County?
Mile west.
Okay, bond is set in the amount of $5,000, personal recognizance. We'll set this case for a pretrial conference where the defendant indicates he will be appearing with an attorney that he retains to represent him. And we'll give you a pretrial date, Mr. Mendenhall. So what you're going to do is you're going to go to the clerk's window. You're being released on your own recognizance today. You'll be given a pretrial hearing date at the clerk's window. If you fail to appear for that hearing, then I could issue a warrant for your arrest, and then I could order you at that point to pay the state of Ohio $5,000 as a penalty for your non-appearance. Do you understand that?
Yes.
Do you have any questions for me?
Yes. When I initially was pulled over, he told me all I needed was proof of insurance and the tag. He pulled me over for the tag. He wasn't for suspended license.
Let me see your citation, Mr. Mendenhall. Mr. Mendenhall, on this citation, it has two charges. Two charges. I don't care what he told you. On your citation, which is what I go by, you have two charges. And I've just outlined to you those two charges and the potential penalties you face. Okay? Any other questions?
No.
Okay, you can go to the clerk's window, they'll take care of it.
I hope you got a good look at that, ma'am. Because there's more. I shouldn't play this next part. I should skip it. I shouldn't play it. It's sort of rude. But it's only 37 seconds long, and I shouldn't play it. But here we go.
19th, 2024, do you recall receiving a copy of that citation? Okay, 23 TRD. Go and tell them to keep quiet out there. Mr. Mendenhall is getting a little emotional. In 23 TRD 712, this is the citation issued on September 23rd, 2023. You were charged with two counts. One, failure to display your license.
In his defense, that judge makes me cry too. That judge makes me want to go to another room and just cry too, because he's very scary. Oh man. Okay. Now we get to the accent. We get to the accent, a little break, and then the accent. And that's all that happens is accent. No, it's just, it's funny the words that are coming from this accent.
You'll give the advisement of rights form over to Sabrina. She'll put that in the file for you. And you said we have already canceled the warrant?
Yes, sir.
I'll just put here so it's cleared up. It's been on my approval.
And that's our one person by Zoom.
Okay. And then I've got Conrad Wood appearing here, and it may be someone other than Conrad, but appearing by Zoom video.
Hello?
Hello, good morning. I can see a hand. Oh, there we go. Good morning, sir.
Can you hear my audio too?
I can.
Oh, okay, good.
Good morning, Mr. Wood.
Yeah, good morning. They've got my name messed up. My name's Dion Conrad Wood.
I see. Okay, because the officer wrote the ticket as...
Okay. Y'all gotta, I have to explain to the Americans, okay? This is New Zealand accent. New Zealand.
Conrad, and then middle initial was D, but your first name is actually Dion, D-I-O-N?
Yeah, that's right. Conrad's my middle name.
Would you like me to just change what we have in our system to having your first name be Dion and your middle name be Conrad then in the system?
Yeah, yes, please.
I'll go ahead and do that. So we'll amend the summons at your request. All right, sir, the charge for you is having a firearm in a sensitive area, which is a violation of section 5815 of the Boulder Revised Code. This allegedly occurred at the Boulder Reservoir on August 3rd of 2024. So the options, and you've heard me discuss with others, the options of speaking with a prosecutor, that's also available to you if you'd like to have a conversation. They can meet with you privately in a breakout room via Zoom, and you could have a conversation with one of them about your case. So that's an option for you. What would you like to do today?
Let me think. I think before I make a plea, I'll ask what I'd like to do.
Judge, can you ask him if he's married? Can you ask him if he's single? Please, Judge? I just need to know if he's married.
I'd like to let you know off the bat that I'm on disability Social Security, and I live here in Provo, Utah, so I was just visiting Boulder that day for the marathon
I'll pay you, honey. It's okay. I'll pay you money.
that took place there.
Okay.
And yes, I did do the charge according to what you charged me with, but I would feel I'd like to plead not guilty. I had no idea that Colorado was that unfriendly to gun rights, so I didn't realize that I was breaking the law by being armed at a city park. I had no idea of that. I just kind of assumed that Colorado, being like most of the western states, was very, very gun rights friendly, and I only thought that Denver, Colorado was a special case. But after researching some of the laws when I returned home, apparently other municipalities are allowed to have stricter gun regulations, and there's no state preemption in Colorado for gun rights.
Gotcha. Okay. Well, why don't you hang tight?
Okay.
And then as soon as one of our prosecutors is available, what will happen is you'll see across your screen, it'll be an invitation to join the breakout room with that prosecutor. So when she's ready to speak with you, you'll see that invitation. You can just click on it, and then that'll take you from this area to the area where she is in a private place where you can speak with her. And then once you've spoken to a prosecutor, you'll return to the main session, and there'll be an invitation to return to the main session or a place where you can click on that. And that'll take you back here into the courtroom after you've had that conversation. Does that make sense to you?
Yeah. Thank you very much, Your Honor. I'll do that.
Okay. So just hang tight for a little bit, and when it's your turn, you'll see that invitation.
Okay.
Yes, let's go ahead and recall the Trong Nguyen case. Mr. Nguyen is back in the courtroom after speaking with Ms. Keller.
Your Honor, I've spoken with Mr. Nguyen. He has shown me evidence that his CDL has been reinstated. I've explained to him that this is a 3-point charge, and because he has a commercial driver's license, federal law prohibits us from either reducing the points to 0 with a plea offer or changing the name of the charge. So the plea offer that I've extended to him is just a plea to a 1-point U-turn prohibited charge without a traffic class.
Okay, does that all make sense to you, Mr. Nguyen?
Yeah, but it doesn't make sense, Your Honor.
It does not make sense?
Yeah, because the cop already give me that point. If I pay the amount, it's already reduced to 1 point. That's why he gave me the ticket, and now she didn't offer me nothing in here when I came to court.
Well, and she may have tried to explain, but let me also explain to you what federal law prohibits, and it puts the prosecutors in a difficult position. They don't have the authority to change the name of a charge, number one. And number two, they can't reduce it to something that doesn't get reported to the Department of Motor Vehicles. Unless they believe that they can't prove the charge, they are ethically bound to follow the federal law. And that means she can't make an offer any better than that. She's stuck. And that's because of the anti-masking law that applies to commercial driver's license holders. So the officer honestly wasn't supposed to make an offer at all. And that was an error because the officer may not have realized that you had a commercial driver's license. And so our other defendants, people who don't have commercial driver's license, are eligible for the plea offer to reduce it to 1 point, which the officer makes on the street.
I would die to get more just regular Australian, New Zealand courts. There just aren't any. And I can get Australian court cases, but they are legit trials. There's no crazy people in them. They're legit lawyers fighting in legit trials, which tends to be sort of boring a bit. So I don't play them much. But man, if I could get regular Australian court cases, oh man.
But you weren't supposed to be even given that offer. The prosecutor's still making the offer available to you. So if you want to accept that and have the point.
I have an idea. I think I have an idea. I think I can get some Australian court cases. I'm going to work on this, guys. I have a really good idea.
It's reduced to a 1 point charge. You can go forward today.
But I mean, I'm driving not a CDL truck though. I'm driving a regular car.
It doesn't matter what you're driving. It matters what license you hold. Does that make sense?
Yeah.
Okay. So the option for you today is if you want to accept the offer, you can plead guilty to that 1 point charge, and then I would be imposing a fine. The other option for you is to set the case for trial, and then the prosecutor has to prove that, in fact, you made an illegal U-turn. If they prove it, you end up with 3 points instead of 1 point, and you would also have a fine. So those are basically the two options that you have. What would you like to do?
Yeah, I guess I accept it.
All right. Let me go ahead and accept the plea. It is to the charge of
I
making.
can't be, I didn't get no offer. She's telling me she's reducing no. There's no reduce, no offer.
She's reduced it from 3 points to 1 point.
A cop already give me that already.
I understand.
Okay?
Yeah.
A lot of people getting an offer, but I ain't
Right.
getting nothing.
Yeah. Did you understand what I explained to you?
Yes, I did.
And frankly, I wish it were different. But I don't control the federal law. The federal law says that people who have commercial driver's licenses aren't eligible for certain dispositions. And the reason that they told me at conferences that I've gone, where I've gone training on this, is that their fear is that people who have commercial driver's licenses who get dispositions that don't accurately reflect what happened continue on the road. And there are people out there with commercial driver's licenses, probably not you, but who have a lengthy history of violations that's not really reflected in their driver's history. And that puts all of us at risk. So
Would a bogan say, I didn't get no offer?
that's why the federal government takes the actions that it takes. It's not my job to defend them. It's just it's the law. And as a judge, I have to comply with it. A prosecutor has to comply with it as well. Does that make sense?
Yeah.
You may not like it. I don't blame you for not liking it.
But she says she does the offers, they don't make sense. It's already did it. If I pay the money, I already get that 1 point.
That's true. That's true.
I ain't wasting my time to come up there.
Yeah, I understand that. Yeah. Let me go ahead and accept the plea. It is to the 1 point charge of making an illegal U-turn on June 20th of 2024 at Baseline and 30th. How do you plead to that charge?
Guilty.
I'll accept that guilty plea. I'm going to set your fine at $70 and there are $30 in court costs. I'm making it a little lower than our normal fine, frankly, because you spent.
Yeah, nothing, but I don't want a record in my record.
Yeah, I can't do anything about that, but I can impact the fine, and that's what I'm doing is to save you a little money on the cost that you have to pay.
Judge Khan, will you please stop trying to explain things to this man? He's not listening. You are over-explaining, which is amazing because you're so kind, and he's not listening.
That makes sense?
Yeah.
Can you pay the $100 today?
Yeah.
All right, I'll send you out front. They'll be with you in a few minutes.
Oh, here we go. He's coming back. He's coming back, guys. Here he comes.
Yes, sir.
Ms. Osweta.
Your Honor, I am ready with Mr. Wood, who appears via Zoom.
Great, thank you. Let's recall the Dion Wood case. And Mr. Wood, if you'll enable your video and your audio, looks like you're doing that. Go ahead, Ms. Zazueta.
So, Your Honor, the city has extended an offer for this matter. The offer is a 6-month deferred prosecution with the agreement not to have any new law violations in the 6-month period. This is not a typical offer in this case, but the city is struck by the fact that Mr. Wood resides in Utah, has no intentions to return to Colorado, particularly after this incident. We had a lengthy discussion about that. And given the fact that from what I had discerned, the laws are quite different in Utah, and that were he at home, he would not have received a ticket. The city does not perceive him to be a safety risk where he needs extra education or sanctions. And so we hope the court will accept this as just a way for him to resolve this matter and move forward outside of the Front Range.
Okay. So, Mr. Wood, the deferred prosecution agreement for 6 months doesn't require anything specific from you except that you go through that 6-month period without any other criminal law violations. At the end of 6 months, the case will be dismissed. Your record will automatically be sealed in connection with that. There is typically a $100 deferred prosecution fee associated with the case. You mentioned to me earlier that you're on a disability. Do you want to share with me where you are financially? I can consider that in deciding how much of that $100 fee to impose.
Yes, I'm on Social Security disability, so I'm on a very tight budget. It gives me just enough to pay for my food and my rent and my bills and my car payment. So it doesn't really leave me much to play with, but that's
Okay.
my only source of. I don't have any other kind of money coming in at all.
All right. Given that there aren't going to be any substantive requirements for our probation department to monitor on this, I'm going to waive the $100 deferred prosecution fee. So you won't have any fee to pay the court. You're just going to have this obligation to not get any other charges during the next 6 months. I do want you to meet briefly with our probation officer who will monitor your case. So you will get yet another invitation to join a breakout room with her, Miss Aubrey. She'll go over all of this with you, make sure that you understand it. She'll make sure we get your signature on the agreement. I'm going to put my signature on it as well.
Yes, sir.
Okay, Your Honor, and thank you very, very much for your judgment on for my case there. I'm very grateful.
You're welcome. I'm glad to hear it. I can't help but say that I went to Utah with my son who loves guns. He's not yet old enough to even own a gun, but he wants to move to Utah when he gets old enough to move because of the different laws that we have in our state. So it's very, very interesting to see someone from Utah be here on the circumstance. But
And I'm not even from here originally. I'm originally from New Zealand, and I really, really love Utah too. It's just a beautiful place. And when I was visiting Boulder, I was very, very surprised at how beautiful it is there. I've only seen it in pictures
Were you near Columbine by any chance?
and video, and it's a gorgeous place. I just hope that the Colorado legislature will pass a state preemption law so visitors like me don't have to worry about a patchwork of different laws from town to town, city to city, you know?
it is the challenge for our state as far as for every state really dealing with the various ordinances that might apply. So I appreciate that. And you come from a very beautiful state yourself. So I'm going to go ahead and put my signature on this deferred prosecution agreement. And are you seeing that invitation to join the breakout room?
Not yet, but I'm sure it'll come up. There it is. Thank you so much, Your Honor. Take care. Thank you.
You be well, Mr. Wood. Thank you.
Crikey. Oh, that was so good. I wish I could play it again because it sounded so good. Okay. Ta-da. Oh. Okay, I hope this audio is good.
Did she say this is the one? Total.
So if you noticed, I have YouTube judges today, which I never do. Well, sometimes I do. But it's because we have all these nurses in chat, and there's this trial going on right now for nurses. So it's not over yet. So I've been getting this trial for nurses, and I'm not going to play the whole trial. Don't worry, CJ. I'll cut it up. I'll cut it up for one stream Promise. Shut up, Kelly. I don't remember this long pause. There he is. There's the star of our show.
Good morning, sir.
Morning, Your Honor.
Okay, Mr. Jones, on October the 7th, 2024, you were charged with obstructing a police officer. This is alleged to have occurred at 2001 Sheridan Boulevard. You were ordered to appear in court December 3rd, failed to appear. You've been in custody at that time?
That's correct, and I made every effort to contact all related parties on the matter, so it was a bit frustrating, to say the least, to be arrested on the failure to appear.
Okay, I can barely hear you, sir.
Finding where the municipal charges were out of was a hassle. Trying to speak to my public defender while in custody and while out of custody were all without, actual action being taken, apparently. So I do apologize for missing court that day. Probably make every effort to contact the court.
Okay, thank you, sir, for that. I do see that you did post a $200 cash bond. Okay, I do see that. All right, so did you have an opportunity to speak with the prosecutor this morning about resolving your case?
Yes.
Okay, how did you want to move forward today? Do you have any questions?
No.
Okay, so did you want to talk to the prosecutor about a plea offer? Because I don't see that there's an actual, like a plea offer with terms of the plea offer in the file. And so I didn't know if you,
Disturbing the peace with a minimum of community service hours to be completed where I've been living in Longmont. But no, what happened to that deal? Which I still think is egregious, to be honest with you, and the essentially the being held while I'm in custody in Jeffco, which this is technically Jefferson County, I believe. You're going to hold me culpable for a failure to appear when I'm being held against my will in Jeffco. It's just, I think it's absurd.
I certainly understand your frustration, Mr. Jones. So your question specifically is the previous plea offer of the 8 hours of community service?
That's fine with me. This is the first time hearing it right now, other than speaking with the prosecutor and having a bit of a disagreement on whether there should be a case here or not at all.
Okay. All right. Miss Rogers just had a question for you. If you could enter your appearance, please.
Suzanne Rogers, registration for OPI.
Thank you so much. The question I just have for you is that there are two purple sheets in the file, and there's one in the file that where it appeared as though at one time you were considering a plea to the charge, no further violations for 12 months, 8 hours of community service. Was that offer ever extended?
Was extended. I think he rejected it, although it wasn't sure what he was objecting to.
Okay.
Discussed the disturbing the peace with 8 hours.
The thing that we did end up talking about was that I would agree to him pleading guilty to disturbing the peace. But then he was saying he didn't disturb the peace. I was explaining to him it was a plea bargain, asked for a lesser charge. And I offered that to him, and he still wanted to argue about whether to give anything.
I don't believe you. I do not believe you that you were trying to offer him a plea and he was arguing with you. I just think that's wrong. I don't know why you're harassing him. I don't know why you're out to get him.
So I told him to go in the courtroom and decide whether he wanted to plea bargain, whether he wanted to not guilty. Get the ACO involved. Which is what he told me to do.
Okay, and is it your position still that if he did want to resolve his case today, no further violations for 12 months and 8 hours of community service? Okay.
Disturbing the peace, though.
Mr.
It's fine.
Okay, Mr. Jones, would you like for me to read to you either of those charges so that you know exactly what the city ordinance says about it?
If I'm not being charged with obstructing a peace officer or obstructing justice, it's just going to be a disturbing the peace, and it's going to be 8 hours of community service. Let's get this out of the way with today, please.
Okay, no problem. So you would like to plead guilty to disturbing the peace?
Sure.
Okay.
I just need to know, where is Bad Tara? I would love to meet Bad Tara. Tara?
All right, Mr. Jones, do you understand that when you plead guilty, you are giving up your right to a trial?
Yes, Your Honor.
Okay, and are you voluntarily accepting this plea agreement?
Yes, Your Honor.
Okay. Are you thinking clearly today?
Yes.
Okay. Under the influence of any substance or prescription medication that would affect your ability to
All of
understand
them.
what you're agreeing to?
All of them.
No, I don't take any medications.
You are accepting this plea offer without the benefit of a lawyer. Are you comfortable going forward without one?
In the spirit of moving forward with things, yes.
You would be pleading guilty to disturbing the peace in violation of Edgewater City Code 10-4-20, which is alleged to have occurred on October 7, 2024 at 2001 Sheridan Boulevard in the city of Edgewater. So do you understand that you are pleading guilty to that charge?
Yes, Your Honor.
And do you agree that there was a basis for the officers to contact you that day?
No.
You do not. Okay.
Dumbass.
Just one moment.
Yep. Just one moment.
I'll need
Have
to read
say
the
yes
police
in order
report.
to get this expedited here, because then fine, let's just say they were probably trying to do their jobs, and we'll leave it at that.
Okay.
Almost all the other, well, not Judge Khan, but almost all the other judges that we see would have stopped this dead right here. No problem. No plea. Time for trial.
Just one moment.
Golden Statue Boy Judge Eric Johnson would have never taken his plea, ever. Hey y'all, what did Friar Tuck do? I thought you were drank too much. No, I don't even know. I just know he has an attitude.
All right. The court will find that there is a factual basis for the contact and will accept the plea and find that it's knowingly, voluntarily, and intelligently made. Is there anything you want me to know before sentencing?
No, Your Honor.
Okay. Just one moment.
You're right, Marty. Good hearing. It was disturbing the peace. Friday is when I work hardest. Friday, Saturday, Sunday. Oh, turkey legs are delicious. Delicious.
Mr. Jones, are you currently working?
Just began some work, yes.
You are?
Yep.
Okay.
It is Edgewater. Zach, that's amazing. Oh, it says so. Oh, I'm covering it. It says so right down here. Ish. No fuss.
All right, the court is
do it.
imposing a fine of $100 with court cost and fees. The total amount is $155. Are you able to pay some or all of that today?
No, I got down to court with $5 in my pocket, so.
Okay. Mr. Jones, because you were on the $200 cash fund, did you want to use some of that towards your fine? That's your choice.
I had discussed with the prosecutor a non-fine situation due to my indigence and an inability to pay at this time. In lieu of that, I was hoping to do some community service.
I see.
That was possible.
Okay. All right, so Mr. Jones, what I'm going to do is impose $100 fine, suspend $100 upon the condition that you complete those 8 hours of community service, and I'm going to waive the court cost and fees, and your bond will be released.
Thank you, Your Honor.
Okay, you're welcome. Do you have any questions?
What is the procedure to retrieve that bond?
Just one moment. So we were looking on your appearance bond paperwork. Normally there's an address on there. What I'm being told is that normally we would mail it to you within 4 to 6 weeks. Did you want to provide an address at the desk outside the courtroom before you leave?
I mean, is it possible just to send that to general delivery in Longmont, 80501? I'll just check it weekly if that's possible.
Okay, just one moment. Okay, I'm being told that whatever address you provide, it'll be sent to you.
Is general delivery acceptable to the court? At a U.S. post office in Longmont, Colorado, 80501.
It's a P.O. box?
No, it's just general delivery.
Oh.
It's sending the letter to the post office, and then I check there weekly for my mail.
Every box will send it to. So it says general delivery. Send it.
Okay, that is acceptable with the court. Mr. Jones, the concern is we just want to make sure that you get your money. That's the concern.
Understood. I feel the same way. I can also offer, I don't know.
Did you want to, is there a way that if we have it?
My place of work might accept it if that's acceptable to the court.
Your place of work?
Yeah, my employment.
Okay,
status.
just one moment. All right, Mr. Jones, if you're okay with this, I need to set a review date anyway to confirm that you've done the community service. So that review date is 6 weeks out. It'll be April 1st, 2025 at 10 o'clock. And And on that date, if you come here to court, we can actually hand you that $200.
Okay.
Is that okay with you?
I think the April 1st is acceptable to me. Is there any way we could set that out another week or week and a half, just because I just started this job and I don't request.
April 15th?
Yes, Your Honor, that works.
Okay. Okay, we'll have a review date, April 15th, 10 a.m. And we'll plan to be able to give you that $200 cash, okay?
Thank you.
All right, you're welcome. If you could just stop at the desk on your way out and they'll give you some paperwork, okay?
Sorry to tie up any more time in the court. What violations am I not supposed to have in that year's time span? What types of violations? Is traffic included or?
It specifies criminal violations that would not include traffic infractions.
Understood. And there would be additional court matters to handle if I had anything come up. Is that correct? Or
if there were any new criminal violations resulting in a conviction.
understood. And should I contact the court if anything were? I was surprised by this incident when I was trying to do the right thing that day. So if anything like that were to arise, I should contact the court.
Yes, you can contact the court.
Okay. Thank you, Your Honor.
Okay, you're welcome. Have a good day, sir.
You as well.
Thank you.
Goodbye, Mr. Attitude. Okay, it's time for Fleischer, but I don't know which one of these is Fleischer, so I'm just going to click around for a second. Maybe I'll get it right off the bat.
I know you rely on your clients to come up with this
I did
information.
not.
What do you want to
Tell you how long it was going to be before you could hear back from them?
That's not it. Nope. That's a trial.
How can I leave a gun at the scene of
See?
crime? It's on me.
I'm working on that trial. I don't think I have the verdict, so I don't think I'm going to play it. Where's all my Judge Fleischer?
For summary judgment, plaintiffs had to come forward with some.
Today, and that should be booked in.
I'm getting nervous.
And count 2 being forgery, a felony of the.
For summary judgment, plaintiffs had to come forward with some evidence on each.
I know I have him. Nope, that's not it. That's only a short little clip. Oh my gosh. Any Judge Fleischer
And
right
also
now.
email them.
Anything. There, this is the one we're going with, guys. This was from the 3rd, so 10 days ago.
That's no good this one? On his MAG and versus email violations. Are we gonna unset her?
Yes.
Great. That's the last one. I think it's just. I'm gonna get just reset.
Hey, what are we doing tonight? All right. No, for the judge.
Get away and get that.
The problem is that essentially it goes away and it's not a conviction. Whereas if I have a conviction where we basically he picks up another one and now it's a third degree felony, you know, so I think it is. Let me unsign it then, and then put you guys, and then we got to get with Miss Jewett as well. Yeah, and I'll time serve him, but yeah, I'll get you know what I mean.
I have those trials that we just flipped through, and all I'm doing right now is praying I have verdicts. That's all I care about. Do I have verdicts? And then if I find a verdict, then I'll go and look at the court case and see if it was good. Hi, KP.
For serious consequences, that's how we. I'll email them, I'll email the fence too. Okay. Well, the problem is he's in custody. Does he have time to do, or is he?
He was out. He was out on bond.
And he was in custody as well. Is he here now? Or is it?
He was earlier. I think they left already.
I mean,
I can have a tour now, so yeah.
yeah.
I'll get you.
Okay. Sure, thank you. Okay. Hi.
Good morning.
Sorry to keep you waiting.
Guys, no worries.
Who do we have?
The new bailiff really does look like he's no stranger to a few push-ups.
Judge, approaching on Wilfredo Vasquez Correa.
Vasquez Correa. Good morning, Mr. Vasquez Correa.
Vasquez Correa. Yes.
Sir, you're charged with criminal trespass.
Trespassando criminalmente.
You were on bond for a criminal trespass. You picked up a new criminal trespass.
Y obtuvo otro nuevo delito de traspasando criminalmente.
Would you hear PC?
Okay.
Well, first I was approached on the new one, which is kind of the same issue as the first one, but I just wanna.
Okay, so Mr. Vasquez Correa, you're charged with criminal trespass. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Please.
On February 26, 2025, at 10:18 p.m., an officer on view multiple trespassers at a business in Harris County, Texas. The officer observed the defendant and multiple others leaning against the front of the business window by the front door. The defendant provided information, and a person check found the defendant to have been arrested from the same location on September 6, 2024. The complainant, the owner of the business, has a trespass affidavit on file. The defendant was identified with his Honduras passport.
Okay.
The only issue is that trespass affidavit, there's nothing filed on that. I don't have a copy of it. It's not a
You
exhibit.
you don't need a copy of it. He needs to just to know that it exists.
He shaved it. This is 10 days old. No.
And he's been arrested there before.
Right.
I mean, I think that there's probable cause to go forward with the case. Mr. Vasquez, every time you go back to this location, you will probably be arrested over and over. There are plenty of other places for you to go to. You can talk to your lawyer and we can find a place for you to go to. But here at this what is this location, please?
Convenience store, Judge.
Es una tienda.
They don't want you there.
No lo quieren ahí en esa.
Don't go back.
No regresen.
You will continue to get arrested.
No, te van a continuar de arrestar.
Do you understand?
¿Usted entiende? ¿Entiende? Conteste. ¿Entiende? Yes.
What did I just say?
¿Qué le dije? ¿Qué es lo que le dije? Repite.
Sí, que no volver a entrar a la tienda.
To not go into the store.
¿Qué te va a pasar?
What's going to happen? I'm a good interpreter. I'd interpret.
Se lo dice porque fui a comprar una pastilla a clínica.
I went to go buy some
Se me dio el corazón.
No, don't go back.
No regrese.
Yeah.
Anywhere else.
En cualquier otro lugar.
Not this place.
¿El lugar?
Okay.
Judge, I was trying to approach because he's got an older case.
Yeah. I'll just raise it up by $1.
Okay. Raise it by $1.
Okay. So for now, I will have you go talk with your lawyer so we can figure out how things are going to go. All I'm asking you to do is please don't go back to this convenience store. Find
For your information, I have it listed as a Salvadorian restaurant.
Un
That's the restaurant
restaurante salvadoreño.
But that's what comes up on Google Maps. There is a grocery supermarket located directly next to it.
Maybe perhaps that's it. Yeah. Okay, all right. Good luck, sir.
Mucha buena suerte, señor.
Thank you. Of course.
All right, thank you, Judge.
Thank you.
All right, Mr. Montanez on the docket. He's set for a bond forfeiture due to a BVR. He is in prevention and recovery center. He's been there since February 3rd. This alleged, he missed the February 7th UA. That's the violation.
Do you have proof?
I do.
Okay. let me
May I
see.
approach?
Yes, of course. You don't have to ask. Crap.
Did you want that out?
Okay. I was trying to move it because I don't.
Oh, okay. Here, I'll
I don't
show
see
you
it.
the picture. Because I took a screenshot of it as well.
Does it have his name on it?
It should.
I was thinking the same
Yeah.
thing.
First line.
So it'll be 1,000.
Do you want to see this?
He showed it to me earlier.
Okay.
Yeah.
So I was thinking maybe we could.
He's supposed to be discharged
His
3/5.
tentative discharge date is 3/5.
So that's
That's
within
2 days
like,
from now.
okay,
Correct. So maybe if we
Oh,
could do
sorry.
like Friday.
done.
Thank you.
Okay, for sure. We'll continue supervision and then just hopefully he shows up on Friday.
Yes,
And
sir.
then after that, we'll just put him on conditions and then,
And I'll keep in contact with the counselor, and if he doesn't get discharged on the 5th, I will let you.
yeah, that's good. Good idea. Please.
Okay.
Thanks, Ray.
Thank you, sir.
Yeah.
Judge, I have an off-docket matter. Can I give you the cause number?
Give me a second. Let me write this down. Hey, bottom of page 20. Where'd it go? Oh. It's Joseph. Yes. Mike Off is upset that you got off. He wants you to stay on.
He's upset.
Yeah,
They're happy.
no, he likes you.
Okay.
So I don't know. I mean, that's why, I signed it and then. You want to go back and talk to him or? I don't know. I mean.
Go back and talk to him.
He likes you, Joseph, Who doesn't though?
Good morning, Your Honor.
Hey,
Hi, how are
hey,
you?
Sonam, what's up?
Judge, good judge.
Yeah.
Judge, I'm covering for Eric Clay. He's
Okay.
taking a jury. I have Mr. Mendoza in the jury box.
That's Mr. Lynn.
Page
Did he
19.
just bond out or something?
Judge, he was sent to a rapid test, I guess, from the note that I have from
Oh,
him.
that's right.
And when he came back on Friday, the court was closed, so he returned today.
Yes, Judge, we rolled him from his court-ordered drug test on Friday. It came back presumptively for THC. And then regarding the drug test history we have, he was originally put under our supervision on October 10th of 2024. He tested positive THC then. We gave him a court reset to allow for time for dissipation. He tested again on the 21st of November, 2024.
Right.
and
This
that
is a
was
whole
negative.
case, so I'm not taking any of that into account.
Yes, Judge.
So, right. So come up, Mr. Mendoza. So, yeah, that I remember, but that's all
Yes, Your Honor.
like history, as they say. No more. I will test you 45 to 50 days from today. If I find that you test positive again, it's not going to go well for you. Do you understand? You're not to use alcohol. You're not to use illegal drugs. I think we ordered him not to drive as well, right? He didn't have a license?
No idea about that. Do you have a driver's license?
Working on it right now.
So
He doesn't.
you're not allowed to drive as well. You're not to possess your weapons. If I find you case violate any of these conditions, you know what happens. Okay?
Judge, and to
Great.
that amendment to curfew,
Tell me.
He has a curfew from 9 to 6, I guess, but he's saying that he gets home around 11 p.m.
Well, if I could get it set to like 12, or I could get like at least an hour from work to home, because I work all the way in downtown, and usually the latest I leave is 11. I have proof of schedule and everything. I already sent
Okay.
it to my
Show
board.
it to Felicia, and then we can work with you. But if I find that you pick up a new case, if you're out other than working, the only reason you can be out is for work. So I'm not giving you on the weekend. Do you understand?
Gotcha.
I don't want, and on the weekend, he's got regular curfew.
I work
I want those bond conditions, please.
well, right now my schedule is looking from Thursday to Sunday.
What do you do?
I work at a restaurant at the Pit Room in downtown.
What's it called?
The Pit Room.
Okay. So on the days you're not working, curfew stands. On the days you work, then, but I don't want you out past this.
Understood.
You understand?
So from like my days
So
off.
if your work ends at 11, you know, how far do you live from the restaurant?
I want to say like 30 to 40 minutes from my work, from my job.
So what time do you get home normally?
It's because there's never a set time. Like it usually just when on average, I want to say like 10:50, almost 11.
Did you get home at that time?
Around there.
I would never have fun without you guys. Never.
They're usually if I do everything I'm supposed to, but if it's busier than usual, usually latest I've gotten out was 11.
Okay, then that's it. All right. Okay.
So 11 to 6. When do you have to leave home?
I mean, if he's working that late, they usually go in later on. You know what I mean?
Yes, Judge.
You know, he's not working at 7 in the
Just want to
morning.
make sure that he's clear about the time that he can leave.
Okay.
Yes.
All right.
Thank you, Judge. Your excuse.
If I'm going out and having fun, my phone is not in my hand.
The 5th. I will be there on.
The other case is 116 days old. So both of them are reckless driving. Probable cause has been found on both. I've ordered you not to drive. I've ordered you not to consume alcohol or illegal drugs, and I'm going to test you again in 45 to 50 days. If I find that you continue to smoke, then you will end up staying with me. Do you understand? Yes, sir. We pick up a new case. I'm going to go absolutely bonkers on your bond. If you fail to stay in contact with the lawyer that we give you, likewise on your bond. Do you understand?
Yes, sir.
So do you have offers on these cases? If not,
Not believe we have offers on that.
can you please put them on?
Yes.
I'm going to give you guys 30 days. You must be back at that time to determine what you want to do with these cases. You must accept a plea bargain from the state, or I will set your cases for trial. Do you understand?
Yes, sir.
Okay.
Thank you.
You're welcome.
Oh, yeah.
Victoria, what did you do to him? Victoria, you have to be nice. You can't keep beating up people like this.
Oh, yes.
Morning, Mr. Wyckoff. The only thing I ever wanted from you is just to be clean. That's all I ever wanted. I didn't want this back and forth into custody, back and forth and this and that. The only thing I wanted from you, I promise you, is to be clean. Had that happened, who knows whether we would be in this mess now. That's all I wanted, man.
And I done lost my job because of you.
I done lost plenty of stuff because of you.
Because of me.
Yes, because of you.
I fall. Really?
So come on.
The felony case that you picked up upstairs, is that my fault too?
Nah, it ain't your fault. That's me right there. But coming 2 times a week.
All I wanted, Mr. Wyckoff, just be clean. That's it. You're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you 30 days in jail with credit for the 13 that you've done. You are giving up the right to a trial, right to
Crystal, I was late today, but it was Judge Fleischer's fault.
compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, there's no turning back. How do you plead to the offense of assault, Mr. Wyckoff?
Not guilty.
Okay, then we will go to trial. I'm not accepting this plea bargain agreement. We will go to trial.
Oh, guilty then. Guilty.
I'm not playing a game with you, man. You know, you've been playing games since day one, man. I'm not playing this game with you.
Are you guilty, Mr. Wyckoff?
Yeah.
Are you really guilty?
She said I was guilty.
Love you, CJ.
Your attitude is such that if it doesn't change, you're never going to get anywhere, Mr. Wyckoff. Sucks. All I want is you to leave better than you came. That's what we all aspire here to do. Attitude has a big thing to do with it. Some people just can't get through to. And I guess that's okay. All right. I'll accept the plea. I'm going to find you guilty. I'm going to send you to 30 days in jail. I will give you credit for the 13 days that you've done. All right.
Thank you, Judge.
Thank you, Judge.
You're welcome.
Thank you for coming back, by the
You're
way.
welcome, Judge.
I'm guilty, but it was your fault.
Chief and I need to talk to you about one of
HGN 6 out of 6, walking.
Good morning, Mr. Ma'am, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. Officers were dispatched to Fairmont Parkway in Harris County, Texas, and the defendant was arguing with her husband in the parking lot and got into the car and drove off, nearly hitting him and causing him to fall to the ground. Witnesses called the police, and officers found the defendant in her vehicle near the exit with the car in drive. The defendant ignored the officer's request to turn the car off, and officers noted slurred speech, red eyes, and unsteady balance, in addition to an odor of an alcoholic beverage. Standard field sobriety tests were conducted, HGN 4 out of 6, and the defendant refused the remainder of tests and was transported to JPC. The DIC was read and the defendant refused. A blood warrant was signed and executed. During an inventory of the vehicle, the officer located 2 stemless wine glasses.
3 days ago.
The glasses contained a small amount of a red liquid smelling of an alcoholic beverage and showed recent signs of consumption. The defendant's purse was located in the front passenger seat and was stained with the red liquid matching the hue of the liquid in the glasses, still wet and smelled of a fruity alcoholic beverage.
Instead, I'm going to find that there's sufficient probable cause to go forward with the case. I am now ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I am now also taking away your privilege to drive. You are not allowed to drive. Do you understand? If
Yes, sir.
I find that you do, I will revoke your bond, put you in jail, and I'm going to make it high. You will be signing an affidavit with me today promising me you're not going to drive. It doesn't matter what you do. Do you understand? Not only that, I'm now placing a restriction on your license that you are not allowed to drive any vehicle that is not equipped with an ignition interlock. I send this order to DPS so that every single officer in this state knows you get pulled over, they'll look you up. They'll see that you need an interlock in your car. And if you're caught driving one that doesn't have one, they will take you to jail.
Micah, I struggle with that every day, getting that damn lipstick off the glasses.
Can you run her NCIC, please?
Yes, Judge. So she only has the one prior from 2000 at a 45 DWI, no other prior DWI.
Okay. Do you have the ability to hire a lawyer or would you like to apply
I
for?
would like to apply for a court appointed.
Okay. Deputy Miranda's going to give you an application for an appointed lawyer. I'll have you fill it out and I'll take a look to see whether you qualify. I'm going to have you come up here, swear to us that you're not going to drive. I will get you to Ramona where you will sign a reset. You will get with Felicia for your bond conditions. I don't know if you have a problem with alcohol or drugs. If you do, now is the time for you to address it. Because if I see it becomes a problem, I will address it for you. And I promise you're not going to like the way that I do it. Do you understand? Okay, come on.
Judge, what's the last name?
Top of page 16.
I don't have the doc.
Oh, stare.
Thank you.
Do you need a cause number?
No, I got it.
Okay.
I'm gonna swear you into the health judge. So just raise your right hand. Do you swear with them that you will not vote of your care at all against this driver's license? Yeah. No, if it was not engineer.
Seven, but.
I feel like I showed this one.
I see an attorney at church. I don't know if you want to go in there. What is it?
I mean, it's already 11:30. If they're not here, yeah, we need to like,
Mr. Mallard, come on up.
oh, this is the same thing. I see that you have a lawyer. I don't know where they are, but we need to get cooking. So, okay. So, Mr. Mallard, you're charged with 2 cases. You're charged with driving while intoxicated, second offense. You're also charged with resisting arrest. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 1st, 2025, at approximately 11:08 p.m., the officer was dispatched to a 911 call regarding a vehicle stopped on the road with the male in the driver's seat passed out on North 8th Street in Harris County, Texas. The officer observed the defendant's vehicle stopped on the road facing the wrong side, forcing multiple vehicles to drive around the defendant's vehicle. The officer observed the defendant's vehicle's engine on, with the defendant sitting in the driver's seat, appearing to be sleeping or passed out. The vehicle was in drive with the defendant's foot on the brake. The officer observed an open container of Bacardi rum, 750 milliliter bottle, approximately 10% full, sitting in the front right passenger seat, and the officer attempted several times to wake the defendant unsuccessfully, which led to the officer being forced to break the defendant's front right window to get into the motor vehicle due to the doors being locked. The officer placed the vehicle into park, and the defendant was asked to step out, who immediately fell to the ground. The officer observed slurred speech, red bloodshot eyes, a strong odor of an alcoholic beverage, and poor balance. The defendant refused any standard field sobriety test, and the defendant advised he had not consumed any alcoholic beverages, wished to speak to his lawyer, and was loudly repeating no consent to all questions. The defendant was read the DIC and refused breath. A blood search warrant was signed and executed. The defendant was transported to HCA Southeast ER to obtain blood, and the defendant refused to exit the officer's motor vehicle, even when the officer asked multiple times. The officer had to physically guide the defendant out of the vehicle, and the defendant stopped walking while walking to the ER with the officer and advised he wanted to go to the Veterans Hospital. The officer advised the defendant he had a search warrant, and the defendant refused to move. The officer grasped the defendant's upper arm and advised the defendant again of the search warrant, and the defendant refused to move. The officer advised the defendant that if he had to pull him inside, he was facing additional charges. The defendant again refused to move. The defendant advised he wanted to go to the VA hospital, and the defendant started pulling away in the direction away from the entrance to the hospital. The officer attempted to pull the defendant to the entrance, and the defendant continued to pull away. The defendant went dead weight and laid down on the ground outside and refused to move while screaming at the top of his lungs, "Someone help me." The officer was assisted by hospital security in placing the defendant in a wheelchair, allowing transport into the hospital, and the defendant's blood was only able to be drawn with assistance of 3 officers holding the defendant down.
My goodness. Can you run his NCIC? Does he also have a felony DWI with a child as well?
It was reduced to a DWI just above a 0.15.
If you have a problem with alcohol, you better address it, Mr. Mallett. Because if you don't, I'm going to do it for you. I don't want you out in the middle of the night, and I'm now giving you a curfew. You are not allowed out past 9 p.m. to 6 a.m., and I'm going to put a monitor on your ankle so I know that you're not out in the middle of the night. On your other ankle, I'm going to put a scram monitor so I know that you're not consuming alcohol. Likewise, I don't want you to drive. I am now taking away your privilege to drive as well. You're not allowed to drive. Do you understand?
Judge 96?
Yeah.
Raise your hand. Raise your hand.
Heed this warning. If I find that you drive, I can have a contempt hearing. Every single time that you drive, it's an offense in and of itself, punishable by up to 6 months in jail and a $500 fine. Do you understand? I don't care what the justification is. Jesus comes, needs a ride to church. I don't care. Do not drive.
Oh, my mic was on. Sorry.
I was trying to read what I was trying to this.
I am also now placing a restriction on your license that you.
Excellent. That's all. Cool. I couldn't see them.
I'm now placing an additional restriction on your license as well, that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle, number one, we're going to have issues with this. Number two, I'm sending now notice to DPS in Austin so that they know any vehicle that you drive is supposed to have an interlock in it. So if you're caught driving a vehicle that doesn't have an interlock, they will take you directly to jail. Do you understand? At this time, you're not allowed to drive. So you will get, well, you got the scram, so I'm not going to give you a portable device, but I don't want you drinking at all. This thing is extremely finicky that they're putting on your ankle. So know what you put in your body. Do you understand, Mr. Mallard?
Yes, sir.
If I find that you consume alcohol, anything that has alcohol in it, cakes, candies, foods, gums, energy drinks, hair dye, I've heard it all.
Beer.
If I find that you're consuming, it's really not going to go well. So I'm going to have you come up here, swear to this. After that, I'm going to get you to Ramona, where we will have you sign a reset. I will have you get with Felicia if your bond conditions, and then we'll have you take a seat while we wait for your guys to get here. Come on. $101? Is that okay?
That's fine.
Yeah.
Okay, so do you mind? Okay, and then just let me know once you get, I'll go however you want to go. Just let me know.
Okay.
Yeah, okay. Thanks, guys. Sure. Thanks, Council.
Sorry.
Okay. Ramona, I'm going to stare on granting.
Okay.
Good morning, Ms. Rice.
Good morning.
Ma'am, you're charged with failure to identify oneself while being a fugitive from justice. That makes it a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 24 days in jail with credit for the 8 days that you've done. You need to understand there's a couple very serious points now. Number one, this is going to go on your record. It will be there forever. From now on, you're facing a minimum of 90 days in jail for any new cases that you pick up. The other thing that you also need to understand is that you're on parole. It's very possible that because you're on parole, by pleading guilty to this, it may result in further confinement. I don't know for sure. They may send you to ISF, but they really could send you back to prison because of this.
Yes, sir.
Knowing this, do you still want to do this?
Yeah.
You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off.
Yes, sir.
And how do you plead to the offense, ma'am?
Yeah.
I'll find you guilty, send you to the agreement. Good luck to you. Thank you, Mr. Pons.
Ms. Ford, for Raymond, DOUR.
Okay.
I'd like to challenge the PC.
Well, that's why I have you here.
figured.
Because I thought it may be problematic as well.
Okay.
So let's talk.
So
You want to hear it again?
yeah, I haven't heard.
Oh, you haven't heard it?
Oh, okay.
Okay, please. Come on up, Ms. Paul.
JK, thank you so much. Thank you.
Okay, so it's a DWI, Class B. Mr. Pons, please.
Yes, Judge. On March 2nd, 2025, the officer was dispatched to an accident call on the 4500 block of Southwest Freeway. The defendant was passed out in the passenger seat of a tow truck, and the officer noticed that her eyes were low, her speech was slurred, her breath smelled like alcohol, and she had urinated on herself. The defendant stated she had one drink and was coming from a club. The defendant showed lethargic behavior, and the defendant confirmed that she was the driver and that no one was with her. Standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant considered a breath, and the results were 0.128 and 0.118.
We have her in the passenger seat of a tow truck.
Right.
I'm here to testify that North cats are dirty too. Dirty cats.
So her statement alone isn't sufficient. That's all they have about her driving.
And Your Honor, in the complete OR, there's further statements that kind of clarify the time period that when this happened. The officer stated that at 7:20 a.m., that's when he was dispatched to the accident call, and he arrived at 7:21. And the defendant stated that she was on scene and she was coming from her residence from a bar called Good Mood that she had arrived at 3 a.m. And the defendant stated she had the one mixed drink only and left Good Mood Lounge at 5 a.m. when she proceeded to head home. And the officer found the vehicle on the right shoulder stalled with the front passenger tire blown out. So the traffic or the encounter with the defendant took place 2 hours according after when she left the bar.
But none of that same. Well, go ahead. Calm down, T.
So do we have an officer that actually sees her in the car in the ditch?
No, Your Honor, the car is just found in the ditch with the tire blown out, and the only thing the officers have to put her in the vehicle is her statement saying she drove and when she left the bar.
Well, that's it then. If that's the only thing they have, no PC.
Why?
Their statement alone can't be sufficient evidence. They need corroboration.
And the corroboration we have is that when the officers arrived, there was nobody else on the scene. It was a crowded freeway. There was nobody else who could have gone to the accident or left the accident because they were on a highway with traffic and there were no other people around.
One, I don't see that the officer said any of that. Two, that's still not going to corroborate that she was driving.
Why are you saying that the statement of her statement in and of itself is insufficient?
That's a rule. I can give you a case if you want.
Yeah. Yeah. I do.
Okay, well, give me time.
Yeah. And I'm willing to, if you want, maybe like we can revisit on Monday.
Okay.
Because I want to give you time. I want to
wait for her appearance. for Monday?
Yeah, I'm going to put her under conditions though, but yeah.
Understood.
Okay. But I'd like to do a deeper dive on the PC and I want to know, is that in and of itself insufficient? And it'll give you more time as well.
I'll reach out to the officer.
Let's reach out Monday and
Her confession can't count, Judge, because she was drunk when she gave it.
we'll do more, I guess, a formal hearing. Ms. Poor, we will have an additional hearing on Monday to determine whether there's sufficient probable cause to go forward. So you need to stay in contact with Mr. Pons and he will tell you how we went forward on Monday. As it stands now, I'm ordering you not to consume alcohol or illegal drugs while you're on bond in this case. Do you understand? If I find that you consume alcohol or illegal drugs, I'm going to revoke your bond. I will put you in jail. Could you guys run her license, please? And any other prior DWIs?
Your Honor, no prior DWIs, and we're running her license right now.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, you are not allowed to drive. Do you understand?
Okay. Your Honor.
Great. So for now, I'm going to have you sign a reset with Ramona. We're going to set it for Monday. You don't have to be here. No. We're going to waive your appearance, but Mr. Pons will let you know how everything transpires on Monday. And then after you sign a reset, I'll have you meet with Felicia for your bond conditions. And after that, you'll be free to go. Okay? Okay, Mr. Pons. Thanks.
Okay, thanks.
See you Monday.
So she needs to meet for bond conditions.
Yeah, she needs to sign a reset, but yeah.
All right, guys, we made it. We made it to the end. Thank you so much. Sorry I was late. You know, it happens. It just happens. I don't want it to happen. I try very hard not to let it happen. And then it happens. But anyway, this should just automatically put you over to OJ. So I'll see some of you in OJ. I'll see some of you later. Okay, again, I'm going to say it. It's Thursday. There's this mental health court. It's every Thursday in the afternoon docket in Colorado. So they're 2 hours behind me. So if anything exciting happens in this docket, I will do. If it's really exciting, I'll have to do a members only. if it's semi exciting but okay for public consumption, I'll do a members. I'll do a live later on today. We will see. I don't know. The docket hasn't started yet. So I might see you later today. I might not. I hope you guys have a great Thursday. Bye, guys. Thank you. It's not on YouTube. I try hard not to get YouTube. Even though today was all YouTube, I don't really get YouTube judges. So it's not on a YouTube channel. Bye, guys.
Got these life that goes digital dreams through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream spot. right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted, sharp. In a way, there's no